So I think we can start.
Okay, I'll start. Okay, good evening, everyone, and welcome to our BicTok session 36, titled Court-Annexed and Judge-Led Mediation, Use and Implementation in Practice. My name is Michelle, and I'll be your host for today's session. Before we begin, let me run through a few housekeeping matters. So firstly, kindly ensure that your Zoom username reflects the name under which you registered. This will allow us to accurately mark your attendance and, where applicable, issue a certificate of participation and also for your CPD points. Secondly, if you have any questions during the session, please feel free to leave them in the chat box. Alternatively, you may also raise your questions during the Q&A session at the very end. So today, to guide our discussion, we are honored to have with us our moderator, Datuk Vernon Ong. Datuk Vernon Ong is a former federal court judge and is currently a commissioner of the Enforcement Agency Integrity Commission. He is also an independent arbitrator, mediator, and consultant. Since his appointment as a judicial commissioner in 2007, he has served on the High Court, Court of Appeal, and Federal Court, and retiring from the bench in April 2023. He has also held numerous leadership roles within the judiciary, including chairman of the Court-Annexed Mediation Committee of the Federal Court and regional council member of the Commonwealth Magistrates and Judges Association. We are truly privileged to have him moderating today's session. Now, we are equally honored to be joined by three distinguished panelists. First, we have Dato Sri Makan Joshi, JP. Dato Sri Makan is a well-respected figure in Penang and internationally through his extensive involvement in global trade networks. He has served for over 5 decades in the Malaysian Indian Chamber of Commerce and Industry Penang, including as president, and continues to hold leadership roles across various business community and government bodies. He is also a qualified mediator through training under the KLRCA and Council of Justices of the Peace. He has also served as mediator in various court-annexed cases at the Penang High Court and is an empaneled member of AIADR. Next, we have Puan Mazia Johari binti Muhammad Tajuddin. Puan Mazia is the director of the Mediation Division at the Office of the Chief Registrar of the Federal Court of Malaysia. She studied law at the University of Wales, Aberystwyth, and an LLM from UiTM. Over the course of her extensive judicial and legal service career, she has served as magistrate, various senior assistant registrar and deputy registrar positions across all court levels, head of the Court Mediation Center in Shah Alam, Sessions Court judge. She is also a certified mediator accredited by the Royal Roads University of Canada. Last but not least, we have Ms. Ramit Kaur. Ms. Ramit is a seasoned dispute resolution consultant with over 25 years of experience across legal practice, corporate counsel roles, and alternative dispute resolution. She is a fellow of the Chartered Institute of Arbitrators and an accredited mediator. She is frequently appointed as arbitrator, adjudicator, and mediator. She was formerly the head of legal services at the AIAC and played a key role in the transformation of the institution and in drafting major updates for the AIAC institutional rules. With this distinguished panel, we look forward to an illuminating and tactical discussion. So without further ado, please join me in welcoming Datuk Vernon Ong and our esteemed panelists.
Thank you, Michelle, for the wonderful introductions. Good evening, everyone, and welcome to our BicTok session. We have three distinguished speakers with different areas of expertise. The first of which is Dato Sri Makan Joshi, a Justice of Peace from Penang. His presentation will be unique and interesting because it relates to a different methodology insofar as the process of mediation is conducted, in this case by senior eminent persons of the state of Penang, which are JP, Justice of Peace. Each of the second speaker, Ramit Kaur, was described by Michelle as a seasoned mediator, and I like the word seasoned. It means she knows what she's doing, and she's very good at it. And of course, the description of Puan Matzia, with her various roles in the judicial and legal service, has made her also another seasoned mediator, very effective in assisting parties to come to a settlement in mediation. Now, each of the speakers will be allotted about 15 minutes or so to speak, following which I will round up on the subject, and then we will throw the session open for Q&A. And you are free to ask any hard questions. The harder, the better. So without much ado, I will now invite Dato' Sri Makan Joshi to begin by giving his presentation. Dato'?
Good evening to everybody. And just to inform that I have been given the opportunity to have a court-annexed mediation in the state of Penang. Appointment was actually given to me by Yang Arif, Dato' Lim Chong Fong. And in the first mediation that I had, it was also a land matter, and it was a dispute between an overseas party who had actually had some land, family land here, and at the same time, it was entrusted to another person. But when I was given the first opportunity, I could read the body language of the two parties. They were talking to each other. So the first indication was that they are willing to come to a settlement. That was the body language that I read. And then when we sat in the room, it was quite easy because they were represented by lawyers, but it was very easy because each of them just told me what they wanted, and we narrowed down, and finally they came to a settlement agreement. The entire process in my first case was within an hour. And then they signed a settlement agreement, and the lawyers prepared the order for the court settlement. The next one was a bit tricky because actually the first time when I was appointed, I was actually in the US. And I told the parties that I will not be able to do it because I'm still in the US, and we wanted to have it a physical meeting. And the parties agreed to wait until I come back. But when I came back, it was just the beginning of the COVID. So we did have a meeting just before the COVID, and parties came together, and we briefly understood exactly what each of them wanted. The second one was a major issue involving the state government, involving a developer, involving the water department, involving the PTG, and partly involving the state legal office. In the first meeting itself, after knowing, we tried to find out what actually transpired. And by the second meeting, we found out there was a bit of a fraud. So, and then we started negotiating. I mean, the parties started negotiating. And because being a fraud, parties started thinking aloud, because if they go to court, it's going to take a long time for settlement. So eventually, we had in between, during the COVID, when there was a time for them to travel, they did come to Penang. And in the short period, we came to certain requirements by each of them. And ultimately, when we found this issue was a bit complicated and involving when it was involving a fraud, the matter was thrown back to the state government, and the state government, through the legal office, decided that they should do a land swap so that the issue is settled in a good way. Even after the land swap, the parties were, the developer was still uncertain because he wanted to know the terrain of the area. So we gave them time to go and do the inspection, to do to get the land office to give them the entire survey reports. And after they were satisfied with all that, then we came to a conclusion. And in the conclusion, it took us about 3 hours to sit down, where the PBA also had to understand what it was, because the land was actually, part of the land was actually assigned to the PBA, but the PBA did not enforce the assignment. So that is where the complication came in. And the PBA had already invested almost about, you can say, a couple of, maybe about $20 to $25 million in setting up a plant there. So ultimately, with the land swap, the PBA could proceed and claim for that part of the land eventually. So then we came to the settlement agreement, and all the parties agreed to the points raised there, and we signed a settlement agreement. And finally, the State Legal Office drafted out the consent judgment, and it was presented to the court, and the court approved it. And that's where we succeeded in the settlement agreement. Any questions?
Okay. So, Dato',
Young Arif is also here. Dato' Lim.
okay. Yes, Dato' Sri, do you have anything else to add?
No, I think that's about it.
That's about it.
Yeah.
Okay, thank you. Very short and concise. Now, may I turn to Ms. Ramit Kaur to make a presentation? Ramit, it's all yours.
Okay, thank you, Dato'. Good evening, everyone. Thank you for inviting me for this talk with such an established panel. I find it a privilege. My talk will be, I think I'm finding an opportunity also to see if, I would like to give some views, some opinions, some sharing, because I come from a background of ADR where it's capacity building, and so perhaps I'm looking at it more this time on that perspective, not so much as a sharing of my practice or my experiences as a mediator. So I would like to focus more on, so of course we know the progress that Court-Annexed mediation has made over the years. I think if you talk about mediation in Malaysia, I think it is happening in the courts. I know there are many private mediations, but it's not active as it's happening in the court. So I find that probably, and it's been successful, and as we can see, and probably yang Arif, Dato' all are here, it is a successful method and to resolve dispute, and as a means of actually reducing case loads. And some matters genuinely should be settled between the parties. I think they genuinely deserve to get a settlement that's beneficial to both of them. But then again, there are, I think the questions or the point that we need to start probably looking at is how do we make mediation as a culture of the first step of dispute resolution or mechanism, so that even before parties step into the court and we are dealing with the case loads, that parties are choosing mediation as a method of dispute mechanism. And I think, so the point that I took, I think the courts, two ways that I think that would assist this. I was looking at it more in terms of leadership, which comes from the courts, and trail down. The leadership has to be from the courts in terms of how do we make mediation as a sustainable culture. And of course, at the background, then we need training. Training helps us, different types of training then help us to equip persons who are officials who are actually handling mediation to do it better. So over the years, we find that training has always been focused more on building skill sets or educating process of mediation or the different styles of mediation. But I find that the focus that we should now look at is the bigger purpose of why we are doing all of this. So I find that in order to have a sustainable mediation culture, every mediation process that we conduct must be carefully conducted. And a mediator who is conducting the mediator must not look at it as in I'm resolving a dispute only, but I'm also creating a culture, I'm having a big purpose. It's actually sending down a message, an objective and purpose. And I think the courts are setting standards. And we need to set standards in terms of mediation in Malaysia because of we are going to ratify Singapore Convention eventually, and I think so we have to start probably. I mean, this is where we are setting standards and see how mediation practices can be coherent, not just within the courts, and how do we work together with private mediations, because every lawyer and parties that comes into the mediation room are having perception, they are learning, they're also learning, they're also seeing is mediation just going to be a simple formal process, or is there a bigger, how are we going to transmit this from just a process to a culture? So I find that through court-annexed mediation and through the leadership of the judiciary, we should look at how standards are being set. And for setting of standard, of course, consistent approach becomes important. And consistent approach where training comes into play, where people are trained there's no one size fits all for mediation. We understand that, but at least to the core, more structured method of mediation, what we cannot do without, or how we can innovate, and all of that. The third point I want to make is about collaborative approach. I find that there's a lot I find that court-annexed mediation currently are being done by court officers in a, of course, different style. It's more of an evaluative style, which is rightly so, because the matter has gone to court, and the judges who are sitting, or the judicial officers, knows what is the precedent and how matters are going to be decided and how the decision is going to come out. And then, of course, they will inform that to the parties and help parties to approach. Secondly, maybe in court, the judicial officers may not have that much time. I guess there'll be time constraint for them. How do they spend enough time to the parties? Facilitative would require more time. But I think we probably need to look at collaborative approach, where how do we have court mediators work together with a list of private mediators, and we can work towards capacity building, because in that method we are also building our mediators eventually in the fraternity. Because everyone is trained quite differently. So this ties back to setting of standard. So if private mediators are doing the way they are doing, and of course courts are doing a little different, I think both can learn from each other. There's benefit on the evaluative approach, or the way the courts are looking at it. And sometimes I find that it is from the recent trainings that I've done as well, and feedback, I find that there are cases and matters where it becomes beneficial to get another private mediator in the room to work together. Of course, the mechanics and all that is something to be thought out, but it is beneficial to get that. So in that way, we are also setting standards and making it more consistent. Again, towards the thinking that at some point mediation, we are going to have mediation settlement agreements through Singapore Convention that eventually is going to come to our courts and are going to be enforced against Malaysian parties. And so it takes time actually to build those. The other point, so I find that the objective and purpose of the court-annexed mediation should be larger, and that leadership should come from the court. So it's not just about settling disputes and closing a file or case, but to look at it as to how to inculcate a culture of mediation, where parties look at it as it's a viable dispute mechanism, and that message can only be sent down by the highest institution, of dispute mechanism, which is a dispute resolution, which is the judiciary. I think that message or that culture can be imparted by the judiciary. So I think the role of the mediators, hence the role of the mediators who are sitting mediating, should be bigger, or they should have probably that purpose, and then that can help a lot. Because we see lawyers that come into the room with the parties, they are also learning. So it's not only they're attending a mediation to solve a dispute, but everyone is taking back knowledge and information of what's happening in the mediation room. So then the next time they have a dispute, they know, they appreciate better. So, in fact, instead of going to court, I can actually settle this dispute, and there's something called mediation, and all of that. So creating that awareness. And the other thing that I find, mediation, parties sometimes are not willing to pay costs for mediation. And for private mediators, they may end up charging, of course, maybe a little higher than what the parties are, willing to pay. But some of the difficulties that I face, that sometimes the additional cost that parties have to pay normally is the venue. It's not just the mediators' fees; they also have to pay for the venue. And if sometimes if venue is sorted, and if there can be some understanding as to how private mediators can be paid in a certain arrangement, and they get to use facilities of the court, that would also help, of course, with whatever mechanism and because rules and requirement that is required. And I also feel that there should be engagement or collaborative effort, not just with private mediators, but institutions. Because we do have the Bar Council, we do have AIAC, BICAM, and our institutions. And I think if we can collaborate effort in that manner and get co-mediation is also an interesting method. A recent mediation, I think Mr. Harbans, suggested that why not we try co-mediation, and we found that that is quite interesting as well, and sometimes can become necessary, especially when you are having matters which are imbalanced between parties, marriage dispute, family dispute, and those kind of thing. Having co-mediation do help. So in that regard, co-mediation could be one where is a court officer, and one where it is a private party who end up learning and getting those standards being set. Because we do understand a lot of people have been trained as mediator out there, but they have not done, because they are doing mediation in private, we may not know, to what standards and how they are actually conducting mediation as such. And I think this pool of capacity, that if it's built up, could be a good resource of having caseloads reduced, and the culture itself. Basically, we're creating another layer where parties willingly do mediation before even approaching to court or going to court, unless it becomes necessary. And then so the next thing I feel is the importance of having structured training, not just training of like general mediation of skill sets and all that, but to also zoom into how to enhance skills, or sharing some of the judicial or persons who have done more, for example, marriage or family dispute, have that certain skills in their bag. They know how to do it and all of that. So so a mediator could learn a lot when they're dealing with different cases. For corporate dispute, mediation may be very different. It may be more of a negotiator. You're wearing a bit of a negotiator hat as well in helping parties, because it's numbers, it's quantum, it's complex dispute. For a family or a workplace dispute, or it's a family business dispute, the skill sets and the approaches are very different. I think looking at specialized training, progressively will also be good, and then we start building skills, people with those skills and that will allow us to have a higher success rate, and we start building experts in those fields. So yeah, so looking at how we can standardize practice and ethics becomes important, because mediators are the only professionals who are not there's no professional body really looking at mediator. So the concerns of ethics becomes important, because we don't want mediation to be a process that's abused. There are concerns that when Singapore Convention come into play, when we have to recognize a mediation settlement agreement, then how do we ensure that genuine mediation cases are coming through? It's not just through the Singapore Mediation Convention itself, but we need mediators to be responsible, and they know that there is certain etiquette that they need to uphold. So which I find there's a little of vacuum as well, which I find this is something where, again, through direction or guidance from the Court-Annexed mediation, we can work together, and I think that can be great as well. Mentorship, shadowing. From my own practice, I learned a lot from shadowing, from looking at a mentor as to how they actually conduct mediation. Mr. Harbans has been kind to sometimes allow us to learn from how he conducts mediation, and that really helps in adopting certain style, and you understand how things are done, and we tend to learn from each other. I find that there's also a lacking of that, because everyone's afraid as to how do we do it, how do we go about this mentoring or shadowing. I think, so yeah, I think that's all I think that I wanted to share. Thank you.
Thank you very much, Ramit. You have shared some insights into the state of mediation in Malaysia. Insofar as whether mediation has caught on as a method of dispute resolution, one. Number two, the structural issues relating to mediation, which is a bit loose at the moment. Number three, the fact that there are different avenues for mediation. You have Court-Annexed, then you have private institutional, and then you have private mediation on top of it. And lastly, you have also shed light upon the need for mediation to evolve into a profession which is self-regulated, so that there will be some ethics, uniformity, and minimum standards that are applicable to all. So thank you so much for your very insightful presentation, Ramit. So now I turn on to Puan Mazia, who is no stranger to mediation in Malaysia. So Puan Mazia, the floor is yours.
Good afternoon. Thank you, Dr. Vernon, ladies and gentlemen. So I think I'll start a bit on the brief background of Court-Annexed mediation, the court's perspective. Okay, so if you want to see the history, the Malaysian judiciary started promoting mediation as an alternative to court litigation in 2010, long time ago, to help parties settle disputes amicably, avoid lengthy legal proceedings, and clear backlog of cases. Initially, judges began mediating cases in their chambers for matters already filed in court. To further support this effort, the Kuala Lumpur Mediation Centre opened in April 2011. This created a dedicated space for mediation, gradually shifting the process from judges' chambers to the centre. The Kuala Lumpur Court Mediation Centre was officially launched on August 25, 2011 by Yang Amat Bahagia Tun Zaki Tun Azmi, our previous Chief Justice of the Federal Court, as he was then. So this is the brief background of how Court-Annexed mediation started. So a little bit on the features of Court-Annexed mediation. In the Malaysian legal landscape, Court-Annexed mediation or CAM means mediation conducted by the High Court judges and judicial officers. That's what it basically means. And it's only for cases already filed in court, civil cases, yeah? And the service provided is free, and cases can be referred at any time after the commencement of the proceedings. Mediation cases heard at CAM is voluntary in nature, except for running down, which is now mandatory, which is now made mandatory. Also, all communications made during mediation are confidential, and also an agreement reached by the parties will be recorded in the form of a consent judgment before the trial judge or magistrate, or by a settlement agreement. And where parties fail to reach a settlement, the case will be sent to court for trial. So basically, that's how Court-Annexed mediation works at the courts. I would like to just add on a little bit on what Ms. Ramit mentioned earlier on training. I think, as everyone knows, the judges and the court officers are not subject to the Mediation Act 2012. It's under Section 2. Therefore, there is no need for training for us. However, for us to be at par with private mediators and other mediators at the other institutions, we also do training. And the recent training that we did was, I think, in May and August this year, 2 batches of a group of 24 officers. These are for the officers by BICM. It was held at the KL Kuala Lumpur court. So we've had 48 this year. It was done the normal 5 days, and the feedback that we got was very, very positive. And currently we've had quite a few hundreds already trained. Our officers are already trained. As for judges, I think we've got quite a number as well. Judges from the High Court, the Court of Appeal, and the Federal Court. We also have quite a numbers that are also accredited. Also, we are. It's also in the pipeline to have in-house training for the officers as well, so that we get feedback and we can listen to experiences by the judges during mediation, which I think will be very, very valuable for the officers. I think we are discussing this with Datuk Lim Chong Fong, our managing judge. We are trying to organize that as well. So for training, as Ms. Ramit said, it's very important. Yes, it is. Without training, I think we can't do much. With training, we know how to approach, we know how to start, and we will usually get a positive feedback, and cases are usually settled. So training is number 1. Yes, that must be done. And also number 2, I would just like to add here, I think we are also in the works to have collaboration with private mediators. I think we are still discussing that. So hopefully we can get more feedback on that. And currently we are also doing co-mediation at our centers. For example, just 2 officers. So sometimes maybe the case is a bit difficult, or the amount is a very, very big claim, we'll have 2 mediators. So it'll be easier for us, and I think we get more trust from the parties. Okay. And also Ms. Ramit also mentioned about promotion and to create awareness, I think. Yes, that is also what we have been trying to do. We've done quite a few things on that. We've done the Jelajah Kehakiman, and we've gone all around Malaysia, I think a few states. I think this year we had gone to, I think it was, if I'm not mistaken, the last it went was Kedah, Alostar. So we've had a lot of government bodies with their booths, but we have our Court-Annexed mediation, where we've met with all the lawyers and the public, so we engaged with them. So I think that's one of the promotion. And also we also engaged with lawyers as well. I've been to a few MIMC, AAC to just promote. So I think promotion, we are doing it. It's in the pipeline for next year. We've got a few ideas of how to go about it. So Dr. Vernon, basically that is the brief background of CAM from the court's perspective. Thank you.
Thank you, Puan Mazia. Very short and sweet as usual. So may I just very quickly summarize? Because the topic for today is actually court-annexed and judge-led mediations, use and implementation in practice. To start at the basics, As we all are familiar, mediation is actually a process of facilitated negotiation, where mediators are the facilitator between the two parties. Most parties to a dispute have a previous relationship which brought them together and which after that tore them apart because of some intervening event. So the relationship could be contractual, contracting parties. It could be familial through marriage or through family relationships. It could be social, school network, old classmates, friends, or it could be someone in your community, your neighbor, next to your left or to your right or in front of you. So there's always a relationship underneath forming the former bond between the two parties. And because of some intervening event, that relationship has been broken or severed or damaged. So to my mind, the primary role of a mediator in this process is to repair the relationship, heal the relationship in order for the parties to begin communicating again. So the line of communication has to be restored. Otherwise, nothing will work. When a matter has come to court, as in cases where court-annexed mediation are conducted, you will notice that the parties communicate through their lawyers, which means the lawyers communicate to one another. And when lawyers communicate to one another, the letters always have the magic words, without prejudice. And they use strong words. We demand this, we reject this, and so on. So that hardly leads to any kind of settlement or building of relationship. So the role of the mediator, as shared by Dr. Sri Makan, Ramit, and Masya, is essentially to create a bridge for the parties to meet each other again. And the mediation is the perfect situation because it will be the occasion where the two protagonists, the two disputing parties, sit in the same room facing each other and looking at each other and talking to each other after so many years. And that presents a favorable condition for mediation to assist the parties. Of course, not all litigants or parties have a prior relationship. And the obvious one are road accident cases. When a victim has been struck by a car, he looks at the driver of the car. He's an unknown person. He's a stranger. So even then, such cases can still be mediated, as is successfully being done in the Sessions Court and in the Magistrates Court throughout the country. So that's my first point. The second point is that court-annexed mediation, as opposed to private mediation, has a fundamental distinction in the sense that when we have court-annexed mediation, any settlement can immediately thereafter be recorded in the form of a consent judgment, registered and binding and enforceable. Whereas a private mediation is a longer route. The parties will have to enter into a settlement agreement, and then depending on the good faith of the parties who have entered into the mediation process, the settlement agreement may be fulfilled. If it is not fulfilled, then one of the parties may have to take it to court to sue for breach of the settlement agreement. And that's incur more cost and more time. And lastly, I think we all need to give credit to mediators. First, mediation is very hard work. It takes a lot of time. It takes a lot of patience. Mediators must have empathy for the parties, and it is very tiring. But at the end of the day, if the parties come to a settlement, then the mediators will feel an overwhelming sense of satisfaction and that it is worthwhile because the parties will then walk off together as friends again. So to my mind, mediation has a lot of prospects, a lot of benefits, and we should all strive to promote mediation. So having said my piece, I'm now going to throw a few questions to the panelists. I'll still start with Ramit. Ramit, in what way can we encourage private mediation in Malaysia, notwithstanding that we have court-annexed mediation?
Thank you so much, Dato. So yeah, so I really find that probably the one is I think awareness has been created for some time now in terms of mediation. But like what Dato said, because if parties, I mean, if they are doing it in a private setup, they just have a mediation settlement agreement, the effectiveness of enforcing that settlement agreement is an issue. It is also because of our Mediation Act 2012, which is due for amendment and it's not been amended yet. I think this will solve probably the bigger thing that we need to look at is hopefully we have the amended Mediation Act soon to give effect to a mediation settlement agreement. As we are supposed to, I mean, as we also ratify the Singapore Convention. I think that's one way. Secondly is if the court-annexed court-annexed mediation centers could actually pass down some matters that are suitable to private mediators. I find that's how private mediators, I mean, we can see a little more growth or trust in private mediation. As I know from COVID, after COVID, we realized during COVID that mediation was the most viable method. And in fact, it picked up during COVID all over the world. And even online mediation became popular during that time as the only method at that time to resolve dispute. So right after COVID, so of course every party, they go to court. The thing that party wants is that they want to enforce their decision. But some matters like family matters, where there's personal connection, like Dato put it so nicely, that at the end of the day it's about relationship. And in this kind of mediation, the focus cannot be, of course, in the right and wrong. It is about how do we solve and move forward. I do find that it is more suitable for a private mediation setup. That's my viewpoint in that kind of scenario. And if there is a method or way, because we do have the practice direction and all that, but I'm not sure how effective that the moving out or giving out some work to the private mediators. Then again, I'm sorry, I'm going back to the standards. So the concern would be the standards of mediation. If it's given out, the fee, how do we help out with parties with cost? Cost becomes a major issue. So I think all this will help in increasing mediation use by private party as an effective mechanism, hence as a culture. Thanks, Dato. I hope I've answered the question.
Thank you. From my little experience conducting mediation in a high court, whenever I ask the parties whether they would like to exercise their right to refer their matter to a private mediator outside, they always say no. For the simple reason, number one, they don't have to pay if they do it in the court. It's free. Number two, not only not have to pay, the venue is so convenient, is in the court. Number three, if the matter is settled, then it can be recorded as a consent judgment. So all these in a sense, court-annexed mediation is a double-edged sword. In itself, it doesn't encourage parties to go for private mediation unless there is some kind of mandatory route for parties to go to, which is what I've always advocated by way of pre-action protocol. As in Singapore, Australia, and the UK, where certain cases, like in Singapore, for example, defamation, you must go for mediation first before you can even file a suit. In Australia, there are cases relating to landlord, tenant, land issues. Likewise, you go for mediation first before you can file a suit. So this way, mediation can take root until and unless the public get the sense of what mediation is and how it works and how actually efficient it is in terms of time and cost, nothing will move. So, right. So now can I come to Dato Sri? Dato Sri, in the mediations that you have conducted in Penang, did you find yourself under pressure because of time constraints that you have to finish it within half a day, a few hours?
To be honest with you, at that time, there was no such thing as a KPI. And we were quite, we found that the parties were willing to come to a settlement. So we, I was very patient in the sense that, we allowed them to take their own sweet time. Because, once we know that they want to come to some kind of an agreement, then we should give them enough time to come to an understanding. You see, I was just told recently that, because BICAM has also endorsed, I think about 30 over, or rather accredited 30 over mediators to the Penang High Court. And in some of the cases where there was a KPI involved, some of my friends who were mediators, of course, the cases were small cases, but they felt pressured because of the time constraint. Like, they were said, okay, try to wrap up the whole thing within half an hour, 1 hour, So with that constraint, the parties involved inside felt pressurized. The mediator couldn't do much anything, or couldn't help them much. So, when you have KPIs, then it becomes difficult. But if you amend in your mediation act, and I think you should you should remove KPIs, to give enough time for parties to come to a settlement agreement. This is my own thinking. Because if you put a KPI, then there's a pressure on the parties, including the mediator himself. So that's one of the issues that I look at. And the other thing is that in the recent cases that we had, the small cases, I think it was conducted by a judge who was actually supervising the case. And the mediator felt that somebody's watching. So they felt, they felt very uncomfortable because, if somebody is watching you and you're trying to mediate between the parties, so they felt a little bit pressured also. Whereas in my court mediation, whatever I was given opportunity, we had a free hand. I think the judges, whoever appointed us, I mean, Young Arif, Dato Lim Chong Fong appointed me in those cases. And he did not participate in any of those things, but he just let the parties come to a settlement and allow me to, sit down with the parties, and we came to an agreement.
Right. Thank you, Dato. Yeah, I agree, because when we sit down as mediators in a mediation session, we do so in a small room, in a small meeting room, or in even a smaller caucus room. And if we feel stressed because of the time factor, the parties can feel it because we're so close to them. And because we're under pressure to get them to settle, they feel under pressure from us. And maybe then they will start to withdraw from the to avoid the pressure from the mediator. So I think time constraint is something that we have to contend with. Hopefully, there shouldn't be any time constraints. Parties should be given time to consider matters and come to a decision when they are ready. Yeah. So now may I now pose a question to Puan Mazia. Puan Mazia, most cases referred to court-annexed mediation are by judges or by mandatory referral in respect of accident matters. How can we elevate court-annexed mediation from procedural compliance to genuine engagement? What, I can't hear. Yes.
Thank you, Dato'. Okay, so to elevate court-annexed mediation from mere procedural compliance to genuine engagement requires a multi-faceted approach focusing on education, mediator quality, party autonomy, and a supportive legal framework. I think that is very, very important. So for example, how we can enhance party and lawyer education by pre-mediation preparation. So we have to ensure parties and their counsel understand the nuances of the mediation process, the benefits, confidentiality, cost effectiveness, preserving relationships, and the differences from a trial. So maybe we can also focus on interests, not positions, and also we have to optimize the mediator quality and role, and by having specialized training and accreditation, and also we should empower parties. Mediators should guide the process and help parties to explore the options. Also, adjust the legal and procedural framework, implement effective sanctions for non-compliance, maybe ensure confidentiality and privileges, and also cultivate the right mindset. So when parties come for mediation, of course, some cases when they come, they say, oh, we were told by the judge to come for mediation. We don't want to mediate, for example. Yes, I've had a few cases like that. However, what we say is, since you're here, why not we just try for mediation? Some are not sportive. Some say they are not forced, they were told by the judges or the officers. But when we say, since you're here, let's try, eventually it will settle. Usually it's like that. It's just we just have to listen to them. For example, if I can give an example of a family matter, parties come and I've had this, the wife would say, I don't want to mediate. I want to go to court. I want my child. That's what they say. But we will say, give it a try. It's okay. So when we start listening to them, when they start crying, then we know they are quite genuine. So I think those are the few steps that we can use to maybe elevate that. Thank you.
Thank you, Puan Mazia. Right, Michelle, are there any questions in the chat box?
Yes, actually, I received an anonymous question, so I'll just read out the question. Okay, it reads, sometimes the case is before a judge who is adamant that the matter be settled amicably, but the clients of the lawyers would not move an inch. So how do you think should the lawyers handle such dilemma that they are in? On one side, they have to please the judge and their clients on the other. So this is the question.
Yeah, can I take that question? But I need assistance. I thought if I didn't answer it fully, then maybe I leave it to you. But I just want to share an experience because I personally went to a number of lawyers just to ask them, because I was doing when we were writing the book, as I was trying to do a little research, and I asked them, why do you insist to sit in a court-annexed mediation with your client when you know perhaps it would be better for your client to be in the room on their own? So they replied to us, he says, look, this is our client. I cannot tell my client that I don't want to be in the room. I'd rather be instructed by the court officer to say, sit outside, we'll deal with your client directly. In that manner, then it's easier for me as well as a lawyer, because then I'm not answerable. I mean, my client won't look at me as though I'm not doing anything for my client. So he said, you need to see from our perspective. Sometimes it's very difficult for us to say we don't want to be involved or don't want to be in a room for client. I'm sure that's not the case for every counsel, but there are sentiments of some counsels, they feel that way. They rather be instructed, they say clearly, sit outside kind of thing, which I feel if mediation is done directly with the parties, without the presence of the counsel, I think from my own experience, the success rate is better. They don't keep looking at their counsel as their someone who who will approve what they say or not approve of what they say. So just to share. Thanks.
Dato', if I can add, Dato', it's just
Please
a little
do.
bit, sorry. I've had cases, as Ms. Ramit said, so the lawyers will come in and tell us, Puan, can you just mediate without us, Puan, and then we will come back later and assist. That's what they say. So to me, it's okay as long as we settle the case. So what I do is I will say in front of the clients, I say, okay, I will see your clients now. Is it okay if I just see them without you for the time being? Yes, Puan. That's what they usually say. Well, I'll say that in front of the parties. And at the end of the day, after I've spoken to both parties, caucus and everything, when I come back, of course, I'll bring in the lawyers. I'll tell them what the solution is, and I give them some time, maybe 5 minutes, to speak to the lawyers and come back whether they can agree to the settlement. But that has happened, Ms. Ramit, and it usually works. You are right. Thank you.
Can I just add on? In my case, lawyers were present, and they asked permission whether they could sit in through the mediation. And I felt that I wanted it to be open. So I told the lawyers, I said, as long as you don't make any comments, if you have got to say anything, you can talk to your clients privately. But during the mediation, you should not interrupt and allow the client to speak. And they agreed on it. And there was only 1 or 2 simple matters where they said, can we have a short recess? And the lawyer went with the client outside, just on a few points of law. And they came back and they said, okay, carry on. So in my case, I think we gave the flexibility for the lawyers to be present, and it was okay with me.
Thank you.
And I would like to add on one more thing. This is nothing to do with the Court-Annexed mediation. Years back, when I was in the Chamber of Commerce, when I was the secretary of the chamber, we had commercial disputes with overseas suppliers and a local member who has exported items to overseas countries, and the overseas buyer refused to pay after the goods have been sent to them. So in those days we never had telex machines, we never had fax machines, so it was all through letter writing, So, but in the letter writing, our Indian chamber in Penang, we have a provision in our constitution where we are allowed to do arbitration. So when the issues came through the High Commission's office, and through the High Commission's office, complaints were coming in. So our stand was very simple. We said the party has sent the goods. The overseas buyer has received the goods. There was no dispute in the goods. Then why is he not paying? So our simple solution was that if you don't pay, we'll blacklist you. So once we blacklist you, all the exporters will never send any goods to you. The moment we say we're going to blacklist, the High Commission's office also will tell the party that you'll be blacklisted, even in the High Commission's office. Then they come to a settlement and then they remit the money. So this kind of things do happen. I mean, I'm talking in those days when the communication was very different.
Thank you. Thank you, Dato'. Very interesting insight. I think that we must also consider the role of mediation advocates, which is counsel coming together with a client into a mediation session who are trained as mediation advocates, not as litigation advocates. They wear a different hat when they come to mediation. And then counsel who have this background and training will be very helpful. But in my case, all the mediations that I've done, I've always requested for counsel to let me have private time with their clients. And I tell them, you go to the canteen, go and have a nice cup of tea, nasi lemak, whatever. When it's done, then you come back. So they're quite happy. And usually when I come back and I tell them, matter settled, these are the terms, happily they go out and draft the terms, sign before them, and then before I know it, it's recorded as consent judgment. So there lies, I think, the importance of the creation of a pool of mediation advocates to complement the role of mediators so that the circle can then be completed for the mediation industry to take off. Until and unless we have a complementary pool of mediation advocates, the mediators themselves cannot push for mediation as a feasible dispute resolution alternative. So now, Michelle, any more questions?
Yep, there is from one more participant, but there's two questions here. So this is the question. From your experience, what are the recurring obstacles that prevent parties from reaching a settlement during mediation? And the second question is very much in connection with the first one. What makes a mediation session effective? Is it structure, communication style, the mediator's personality, or a mixture together with a mediation advocate's style? So these are the two questions. The first one, recurring obstacles. The second one is what makes a mediation session truly effective.
Thank you. Any panelists would like to take the question?
I'll share my own experience. So I find the obstacle, so I've had a few instances where I was passed down matter as well from the court. But in those cases where I'm not sure whether it's because of their counsels or it's the parties, but I believe in my session it was more of the parties. The parties were not even keen to get mediation done. So I think the bigger obstacle would be you need to have a willing party in the room. So sometimes you do have parties who are just not willing and who one of them are and the other one, either who just wants the day in the court or something. Yeah. So I think that for me is the bigger obstacle. But in terms of the question of what's the recurring obstacle, I think I really feel it's them not being aware as to how effective especially in private mediation, how effective a settlement agreement will be, or whether the other party will comply with this settlement agreement, and also how much information can they relay, and will that be used against them, despite our promises of confidentiality and all of that. It is sometimes hard to get to that. That could be some of the recurring obstacles that I do see.
Thank you.
Datuk, if I can share, Datuk, from the court's perspective, Datuk, sometimes if parties are not serious, they come in because they were asked to come, and so they will just be there just to listen, and maybe halfway, maybe 1 hour later, they just say, I'm not interested, we want to go to court. So that is one of the obstacles. And maybe the other one is that if I am sometimes it's the lawyers, sometimes, Datuk, yeah, but not all the time, just one or two, when they prefer to go to court. So even if their clients want to settle, they will say it's better to go to court. So those are the obstacles that I have. Not many, Ms. Ramit, but there are just a few. However, we do have lawyers very, very pro Court-Annexed mediation, which we are very thankful. And we see certain lawyers, we know this lawyer A, B, C, D, when they come in, oh, we are very happy because we know they will try their very best to settle. But these are the obstacles that I see from the point of the court. Thank you.
Thank you, Mazia. Dr. Jumakin, anything to say?
Not really.
Not really, right. I think as much as mediation is a wonderful way to settle disputes, we have to accept the fact that there are some disputes that are not suitable for mediation. They're just not suitable for mediation. I can't think of any, but I have encountered a few. But the disputes that are eminently suitable for mediation are always based on a underlying prior relationship of the parties. Family matters. I wouldn't say it's easy, but not difficult to mediate. Neighborhood dispute matters. Joint ventures. Contractual matters up to a point. Shareholder disputes. These disputes where there was a strong relationship between the parties before the dispute is the foundation upon which I always build in order to start the mediation process. And once you can do that, you find this, you are 50% there. If you cannot establish or heal the relationship by allowing the parties to at least face each other and communicate again, then it's very hard to reach a settlement. And the role of lawyers, unless they are trained in mediation advocacy, they tend to be obstructionist because they will tell their clients that this is not, you're giving away your right, this is a point that you should never surrender, and so on. So that it throws a spanner into the wheel all the time when there's a possibility of a mediated settlement. So that's my take on it. Michelle, any more questions?
Okay, I just received one more question. Okay, so this is the question. Should the collaboration between court and private mediators materialize? What is the proposal suggestion regarding cost? Will it still be free, or perhaps there are certain costs applicable?
Fair question. Maybe I'll put it to Puan Mazia first.
Thank you, Dato. Dato, I think it's a policy question, Dato. Policy of the court. So I cannot really comment that much, but what I can just repeat, I think it's in the pipeline, collaboration with private mediators. I think if we do have this collaboration, I think it will really open up the field of mediation, of court-annexed mediation, and I think it will also boost up settlement of cases with the assistance of private mediators, and we can see a variety of options that we have to choose from, mediators, I mean. And maybe as Ms. Ramit was saying just now, maybe if they sit together in mediation, maybe that will also be very, very helpful and encouraging. So I think that is just my personal take, as it is a policy of the courts, which we still are currently discussing. Thank you, Dato.
Thank you, Mazia. Ramit, any comments?
No, Dato, I don't have. I think Puan Mazia has actually addressed it. It will be something very good, and I feel, I think it will be very good to build, like, was very interesting, Dato mentioned, and it's good, something I'm going to take away about the mediation advocate, because it's a great field. But in relation to the question, so I think the collaboration will be very good. Of course, one has to think about how it's going to be done efficiently and not. But it's something that should be encouraged, because then I feel the courts should take leadership in terms of setting the standards. And I don't think it should be left to the private mediators to, if it's not going to happen in the private mediation. I think the leadership should be with the courts as to how they grow this pool of mediators, that and perhaps the best way is when they work together. I think so.
Since we have the presence of eminent Judge Dr. Lim Chong Fo, may I invite Dr. Lim to give his views?
Right, good evening all. Thank you, Dr. Vernon. And good evening to Dr. Sri Makan, to Puan Mazia and Ramnit. Yes, we are looking towards a collaboration as mentioned by Puan Mazia. And if I can maybe divulge a bit more, I think, like, for example, the Penang GPs, I think we'll continue to encourage them to help us. And I think the policy is at no charge. I think that will carry on. I think another group that will be most likely coming in will be the Bar Council mediation. Most of them are lawyers, I think. Not all of them are lawyers. But we are negotiating with them to come in with a minimal charge. So that is still being discussed. So because I think we do have a lot of cases, and the existing pool we have in court, judges and officers, even with the JPs, I think there's still room for others to come in. So, but I think for bar mediation, I think one of the requirements will be to be mediated at their center rather than at the courts. Whereas I think for the JPs, I think in Penang, it has been done in the court. It has also been done outside the court. So I think that's the Wisma Penyayang, I think, that's still being allowed to be used in Penang. So we are more flexible for the JPs. So also I'm trying to get retired judges, including Dr. Vernon, to come back. So that hopefully will also be implemented next year. And yes, I think the other group, I think likely to come in will be the Selangor JPs. So I think just like what the Penang JPs are doing. So yes, I think basically, I think, what must did I leave out any group?
No, Dato. I think that's
Yeah. So
currently.
that's what's in the pipeline. So I think we're encouraging more people to come in to help.
Thank you very much, Dr.
You're
Lim.
most welcome.
I think one stark feature of mediation is that mediators and mediation as a whole is undervalued. Undervalued in the sense that parties do not see the value in mediation so as to be prepared and willing to pay mediation fees to the mediator. And that is the biggest obstacle and drawback. But that does not appear to be the case in other countries where mediation has taken root. In Australia, in the UK, in the US, in Hong Kong, or even in Singapore. But in Malaysia, that seems to be the most difficult obstacle to overcome. So hopefully, under the helm of Dr. Lim and the Malaysian Bar and everyone else involved in mediation, we'll be able to get it moving so that over the years ahead, the mindset will change and the culture will then become a fixture as far as dispute resolution is concerned. Yeah. So Michelle, any more questions? We are almost at 6:45.
Yeah, actually, I think that's all from the audience.
Okay. So any final words from the panelists? I'll start with Dato Sri.
Yeah, one thing that I would request Young Arif and also Puan Mazia, since you are involved in the amendment of the Mediation Act, to make it compulsory for mediation before any court matters can be brought up. Just like what has been practiced in the US and many of the other Commonwealth countries, where it is mandatory to go through a mediation, and before, only unless you fail in your mediation, then only you can go to the court for matters. In that way, I think you can lessen the burden of the courts also.
Thank you, Dato. Ramit.
All right. Thank you, Dato'. And I think the fact that the court next mediator, Yang Arif, and all of that are already speaking about it and doing so much. I think there's a lot being done at this stage, and we understand the value of mediation. I think as long as we keep going at it, and of course creating this mediation advocate, which I think it's a very good thing, because through mediation process, if it is prepared well, if it is done very well, counsels can actually get a lot for their clients. But the preparation part becomes important. So perhaps when we look at it as how beneficial it is, if we have a advocate who does this preparation or focuses on mediation, that's another field of expertise that we should encourage and grow in. I think that's where we can see settlement agreements that are much more interesting, that will come out, and that are viable. Beyond that, just very thankful to be in this panel today. Thank you.
Thank you, Ramit. And last but not least, Masya, any final words?
Thank you, Dato'. I think we are all looking forward to the collaboration with private mediators. I really, really hope it goes through and smoothly, hopefully by next year. Also, please come for mediation. We are ever willing to assist you in your cases. For example, in KL, we have 7 mediators, and our next date is the next date for us is only in December. So we have a lot of slots still. So please come for mediation. We want to assist you. Thank you very much.
Thank you, Masya. Well, I have nothing else to add except to hand the mic back to Michelle. Thank you, Michelle.
Thank you very much, Dato' Vernon Ong and our panelists for their very insightful discussion. And also thank you to all of you for joining BicTok session 36. We are also pleased to share that our last BicTok session of the year will be held on the 3rd of December 2025 from 5:15 p.m. to 6:45 virtually on the topic of review of the 2025 arbitration case laws and developments in Malaysia. So do keep an eye out on our social media pages and websites for further updates on this and other upcoming sessions in 2026. Thank you once again to everyone, and have a pleasant evening. Thank you.
Thank you. Good evening, everyone.
Thank you.